Now, we've mentioned this concept previously, insurable interest. Let's talk about it a little bit more. A party can protect itself from risk of loss, the burden of damage occurring to goods before they are in the hands of the buyer. A party can protect itself by obtaining insurance. Insurance companies, however, will not insure property unless the party seeking insurance has an insurable interest, meaning you cannot go obtain insurance on your neighbor's vehicle. Why? Because loss or damage to that vehicle will not cause you to suffer any sort of financial loss. An insurable interest exists when loss or damage to something causes a person to suffer a financial or other kind of recognizable loss, meaning you must suffer because of the damage to the good. So, definition of insurable interest: a property interest in sold or leased goods that is sufficiently substantial to permit a party to insure against damage to the goods identified in the sale or lease contract. So once the goods are identified in the sales contract, a insurable interest is created, and the buyer of the goods can now obtain insurance on the goods even though it does not have possession or title to the goods. Title will create an insurable interest that if a buyer has goods, the UCC recognizes that the buyer has an insurable interest if they have acquired title. However, even if they don't have title yet, the UCC allows the buyer to obtain an insurable interest in goods without title, the absence of title, as long as the goods are identified in the contract. Both the buyer and seller may have insurable interest in the same goods. As long as title has not passed, both the buyer and the seller may be able to insure the same good. The reason being that at that point, both the buyer and the seller may incur loss if something happens to the goods. So the UCC rules regarding insurable interest provide that even if title has not passed, both the buyer and the seller can have an insurable interest in the goods, so long as the goods are identified. Now, a seller maintains its insurable interest as long as it retains title to the goods. When title passes to the buyer, the seller no longer has an insurable interest in the good. Finally, let's talk about risk of loss. The UCC provides default rules in the event that there is some accident, mishandling, or theft that causes damage to the goods. Risk of loss is the term describing which party should bear the burden of risk for damage occurring to goods after the sale is complete, after the contract is executed, but before delivery has occurred. So if a seller is based in California and they execute a contract for the provision of bicycle frames to a dealer in Wichita, Kansas, the seller is going to place those goods into the hands of a third party, a freight carrier, maybe multiple freight carriers. Things can happen while the goods are in transit. They may be damaged by flood or by fire or by moisture intrusion or by accident. Any number of things can occur to goods while they are in transit. And so this is why we have to think about risk of loss separately from title. Now, once upon a time, risk of loss always followed title, meaning whichever party owned the goods, whichever party had title to the goods, also bore the risk of loss to those goods. The UCC separated those two concepts, meaning the buyer may bear the risk of loss even before it acquires title. Now, in any transaction, the parties should allocate risk of loss. At what point in the transit of these goods will the risk of loss transfer? The parties should include that in the contract. If they don't make specific provisions in the contract, then we turn to the UCC to answer this question of who bears the risk of loss, the seller or the buyer. Now again, by agreement, the parties can always control when risk of loss passes from the seller to the buyer. That seller in California and the buyer in Kansas can agree on the transfer of risk of loss at any point during that transit. If the contract does not specify when risk passes, the parties omit that term, the UCC provides that term. And the UCC will allocate risk of loss based on whether the agreement is a shipment contract or a destination contract. So let's talk about those two in a bit more detail. Now, under the UCC, there are risk of loss rules. First, starting with agreement. The contract between the parties always controls, meaning the risk of loss rules found in the UCC are irrelevant because the parties have specifically agreed to risk of loss provisions. Delivery by common carrier other than by seller, we're going to talk about that in a second. And finally, breach. Again, we'll spend more time talking about breach, but the general rule is the breaching party is liable for any uninsured loss, even though the breach may not have caused the loss. It may not have caused the damage to the goods. But let's go back to delivery. Delivery by common carrier other than the seller, meaning the seller is going to place the goods into the hands of a third party, UPS, FedEx, DHL, any number of freight carriers. Risk of loss shifts from the seller to the buyer at the time that the seller completes its delivery obligations. Whatever the contract provides for delivery, risk of loss happens upon delivery. So how do we know when does delivery take place if in fact the goods are leaving the premises of the seller, traveling for 10 days before arriving at the place of business of the buyer? So how do we know when delivery occurs? Well, we need to look at the contract. If it is a shipment contract, and this is the default contract, and again, we'll talk a little bit more about what a shipment contract is. But if it's a shipment contract, risk passes when the goods are placed into the hands of the first carrier, meaning when the goods leave the loading dock of the seller and are placed in the hands of the first carrier, whether that's the only carrier or whether that's the first and there's going to be multiple carriers down the road, risk passes when the goods are placed in the hands of the first carrier. If it's what we call a destination contract, then risk of loss remains with the seller until the goods reach the buyer's destination, the place that the buyer has designated that the goods are to be left at. That's a destination contract. So shipment contract, risk passes when the goods are placed in the hands of the first carrier, meaning up until that point, the seller retains risk of loss. If the seller places the goods into its loading dock the afternoon before they are to be picked up, and that night lightning strikes and the goods are destroyed, the seller bore the risk of loss. Once they've put the goods in the hands of the carrier, however, their risk of loss has passed to the buyer.